Can landlord file themselves or they have to have an authority? Let's say we are in court now. And again, it's a second mediation at this point. So we reached an agreement. Let's say it's a payment plan or tenant needs to vacate at a certain point. What happens after? If or when you go in front of the judge, do you see that our judges in the city, they more tenant friendly or landlord friendly, or it's all over the place?
I would say most of the judges are.
We're here to share insights and experiences, not legal or accounting advice. Be sure to talk to your attorney, accountant, or professional advisor before making any decisions. Everyone's situation is different. Get the help that is right for you. Welcome to the Philly Landlord Guy Show. My name is Yuri Skripnichenko. The guy with a crazy last name, do not try to remember it. Just think of me as Philly Landlord Guy. I am a licensed real estate broker, certified property manager in city of Philadelphia. And today we're joined by Philadelphia eviction attorney Len Mancini to break down what it actually takes legally evict a tenant in the city, from what documents you need to court times to what happens if your rental license or let cert isn't in place. We're covering it all. So let's jump right in. Today I have eviction attorney here, Len Mancini, a great person. I've been working with him for multiple years, and he will be sharing a lot of information about evictions in the city of Philadelphia. Len, welcome. And if you can introduce yourself and tell us a little bit more about how did you get on this and how long you've been doing this?
Sure. Good afternoon, my friend Yuri. I've been doing evictions for over 25 years. When I started out, it was a very small part of my practice. But there's a lot of people who do only a little bit delving into this, but there's only a few who do a whole lot of it. And it just became a bigger and bigger part of my practices. One client heard that I did it, they referred him out, and the practice just grew and grew and grew to the point where it was enough to make a living at. And I enjoy it, and I enjoy meeting the different tenants. They're always interesting and fun to talk to. You meet a wide variety of people, also landlords. You meet a wide variety of people. So it's an enjoyable practice.
Well, that's great that you're enjoying it, because sometimes evictions, or most of the times evictions, are not enjoyable.
Not for the people involved. That's correct.
Yeah. So you've been doing it for 25 years. That's a long time. And I think I've been working with you over 10 years now. I was looking into the history before this recording, and I was like, I've known Len for a long time.
And I didn't realize it was that long either, to be honest with you.
Yeah, and I just still remember my first experience with eviction. That was about 10 years ago, how shocked I was from the whole process. And that was 10 years ago. So in 10 years, we had a lot of changes, and it looks very different now, or the time frames are very different. So
the time frames are extremely different. And yes, the whole process has changed.
The whole process.
Quite a bit.
Yeah, especially since the pandemic. So let's start with the basics. What are the legal requirements before a landlord can file for eviction in Philadelphia?
Landlord-tenant court is what's called a codified court, which means you have to fulfill certain requirements to actually even be entitled. It has to be a landlord-tenant relationship first. So if you're trying to evict a squatter, landlord-tenant court is not your place. They have to have paid you rent, or you need a lease. The basic requirements you need are a rental license, a certificate of rental suitability, assuming it's a relatively new case. There's some exceptions to that, and a lead safe certificate. There's also some exceptions to that. If the property was built after 1978, you don't need a lead certificate. And those are the three basic things you need to file a landlord-tenant complaint to get it approved by the court. Before you do that, though, you're supposed to go into what's called now the Eviction Diversion Program. And in order to do that, and that's getting ready to change a little bit too in the next 45 days, which it's not completely out yet. So they're getting ready to release it. I believe it's June 16th, but there'll be some minor changes with that. But at that point, we need a lot more information.
Well, let's dive into the eviction diversion program a little bit later. Let's start with the eviction and what the requirements. So you mentioned that you need to have rental license, rental suitability certificate, and let certificate if
those
the
are the
property.
basics of what you need. You should
Okay.
have a lease, but a lease is not a requirement to get into landlord-tenant court. There are oral leases. So it is not a requirement. Those are the three basic requirements you need to get into landlord.
Okay, and something that you mentioned in the beginning, that you have to file with the tenant landlord court, and that may be very different for people who's not, or who's from out of city or out of state, because our court system is not the same as in the state and not the same as everywhere else. We have separate court for landlord tenant cases. Is that right?
That is correct. I don't know how other jurisdictions are as far as states, but as far as even the counties have a different practice. As far as the city has one big court, the counties use little magisterial districts in each of their little separate areas, and they have different, each one has different requirements.
Yeah, it's definitely not easy to keep track of all of them.
Yep.
So what happens if a landlord is missing one of these requirements that you just mentioned, one of these documents? Can they still file?
Theoretically, yes, you can do what's called a 109 affidavit and say you'll provide it at court. But if you don't have it, you just wasted your money, because you cannot proceed at court without all the documents. They will throw your case. If you can get it through filing, they will throw it out at the hearing if you don't have all your documents.
That is very interesting, and we're going to get to it later, but keep your foot on that. So another question is, when you file, can landlord file themselves, or they have to have an attorney involved?
No, they are not required to have an attorney in municipal court. If it's a corporation, you can get what's called the authorized rep form, and the corporation can be represented by a member of the corporation. Individuals can represent themselves. Individuals theoretically can even represent a family member as long as they have the authorized rep form. I don't recommend it, but yes, you can do it. If the case gets appealed to CP court, you have to be the owner of the property. If it's a LLC or a corporation, they have to have an attorney. There is no authorized rep in common pleas court.
Okay, so if you go to common pleas, if your property is held an LLC or corporation, you will have to have an attorney. But if you're going to landlord tenants court, somebody or a member of LLC or owner of S corporation or whatever corporation can represent themselves, as long as they have this affidavit, like whatever paper that they need to submit. Okay, so let's say now we have the requirement or all of these papers that are required. We know that we can file for eviction. So we go and file for it. Can you walk us through the full process from beginning to the actual account, how it all works? And I know that you mentioned the eviction diversion program, so we'll dive into that, what that is and when that comes in play.
Clarify that for me. I'm not you want to know if an individual goes over, or what documents they need, or where they go, or are you looking?
No, after we have all of the documents, we already cleared that. We need to have let's search, we need to have rental license, we need to have rental suitability certificate. So we have all of that, we go and file for eviction. What happens after?
Well, next you'll schedule a hearing date. So if it's an individual, if they don't have access to file electronically, they would have to go down to the 10th floor at municipal court, and there are people down there who would help them file everything. If you give all your paperwork to an attorney, the attorney will file electronically online. And basically what we do is we input all the information onto the website. It creates a complaint. We download all of the exhibits onto the complaint, and we schedule a hearing date. And once that gets approved by the court, it then gets served on the tenant.
Is it only attorneys that can do it online, or myself as a landlord, I can go online and fill out that as well, or I have to go into the city?
So I'm not 100% sure about that. I know previously, if you went through the training as a landlord, I believe you can get access to file online. I'm not sure at this point. I know when this originally opened, but that was 15 years ago. Yes, an individual, as long as they went through the training, could be approved to file online. Now I don't really know what the requirements are.
Okay, so going back to filing, at which point eviction diversion program kicks in, and what is that?
So the eviction diversion program was created during the pandemic, during COVID. And basically what it is, I look at it as a 30-day cooling off period between the parties. So in order to file, you have to go through diversion first. And once diversion is approved, you have to wait 30 days before you can file your landlord-tenant complaint. For diversion, you're basically inputting a lot of the same things you input for the complaint. However, once it gets approved, they will either schedule it for a mediation, or you're supposed to negotiate with the tenant individually and try and work something out before you actually get it into court. And once the 30 days is up, if there's no agreement, then you can file your landlord-tenant complaint.
What if there is an agreement during this 30 days?
Well, then you'd live up to the agreement. So mediation, you can pretty much come to any agreement you want. You can come to a payment plan where the tenant agrees to pay their rent plus something towards the back, or you give them 30 days to pay everything in full, or they agree to vacate. So it's whatever you can agree to. It's to avoid basically filing in court against the tenant. And if they don't live up to it, you have the right to file your complaint right away.
Do you have to agree to something during the mediation process?
You are not required to agree to anything. The requirement is to negotiate in good faith. So you can't just walk in and go, I'm not doing anything. So if you go in and you want the tenant to leave and you say, I want the tenant to leave in 2 weeks, that's good faith negotiation. Whether the tenant wants to do it or not, you don't have to break from that. That's what you want. You can't just go in and go, I'm not negotiating, I'm not doing anything. That's not considered good faith.
So what do you usually see when this mediation happens? What do you usually see as an outcome? Is it some kind of payment plan, or it's tenants moving out?
Every case is different. There's no way of knowing, because a lot of it depends on what the landlord wants to do, because we're taking our instructions from the landlord. If the landlord wants them out, we try and work out an agreement where they're going to vacate. If the landlord's willing to do a payment plan, we'll work out some kind of payment plan. But it really is controlled by what the landlord wants to do.
Okay, and the EDP also comes with TFA. I know it's a lot of
targeted financial assistance.
Yeah, but it's targeted financial assistance for tenants, but kind of for landlords as well. Can you talk a little bit about that and what that means if landlord accepts that?
So targeted financial assistance, as it stands right now, because they do change it every now and then, if the tenant, they can owe more than $3,500, but if you file for $3,500 or less, you can get what's called targeted financial assistance if they qualify. It's not a guarantee. The tenant still has to participate and put their application in. The landlord has to put their application in, and then they qualify. You'll get paid up to $3,500 in your arrears, plus 2 months going forward. The downside to it is you cannot file your landlord-tenant complaint for 60 days after the last month is paid. So just as an example, if they paid you through May, you couldn't file until August 1st. So if they don't pay you, you get paid through May, but if they don't pay you for June and July, you can't do anything until August 1st.
Before we continue, I would like to take a moment to thank our sponsor, TrustArt Realty, property management company in Philadelphia. If you are a landlord, you know that managing properties in Philadelphia can be a headache. And as we just spoke to Len, you know that it's not easy to do an eviction. So that's why TrustArt Realty is offering to all of our listeners a free rental analysis or management advice session. Whether you need help understanding market trends or improving how you're managing your property, they've got you covered. So to claim your free rental analysis, just send an email to trustartrealty@phillylandlordguy.com or click the link in the show notes to fill out a quick form and somebody will get in touch with you. Okay, and August 1st, that's actually the time when you can start the eviction process.
Right, you can go straight to landlord-tenant court. And one other thing I forgot to mention is If you file your landlord tenant complaint during the TFA process, they will not pay out TFA. As soon as you file the landlord tenant complaint, even if you're approved for TFA, that you're not allowed to collect TFA. They'll close your application. So you have to, basically, as the landlord, you have to agree not to file your complaint and accept the money.
Okay. So let's say we filed for diversion program. We went through mediation. We had an agreement in place, or we didn't have the mediation and it's past 30 days and now we can file for eviction. So finally, we're at the timeline when we can file for eviction. So we go and file. What happens after?
Yeah, once you file, then the minimum time to get a hearing date is 21 days under the law. Right now, they run, it's generally around 30 days, give or take, to actually get a hearing date. And then that's basically your day in court. As a general rule, there are a lot of tenants now getting attorneys to represent them. There's a lawyer of the day program. There's lots of programs down there. And a large percentage of the tenants now get attorneys. Also, if the tenant comes down themselves, we negotiate with them. It's the same type of negotiation that's in mediation. The difference being now, if we can come to an agreement, that agreement will be put in writing. It'll be a judgment. And if they don't keep to it, you can start the eviction process. If you can't come to an agreement, the case is set up. Either you have the trial that day or you'll continue it for a trial.
Okay, so you said that a lot of tenants have representation now because they can get it for free. There are a lot of tenants, I guess, groups and organizations who provide it. And there are actually a few zip codes in the city that specifically have free attorneys that tenants can request if they reside in those zip codes.
Correct. And they're expanding that. They're going to expand it out to the whole city.
Yeah.
All tenants are available, but they're targeting certain zip codes.
So what does that mean for the landlord if a tenant gets representation? Like how does that change the structure or?
It really doesn't. It's just that from my point of view, I'm negotiating with their attorney as opposed to the tenant. It doesn't really change anything.
Does it usually help tenants to get out of more things that they would usually do, or?
That's hard to say. Some tenants are very good at negotiating and they know, everything from top to bottom. It's very hard to say. I will say if you go in as an individual, not an attorney, if you go in by yourself and you get an attorney on the other side, it could make it a lot more difficult for you because they know all the ins and outs and they're going to play hardball with you because they're not concerned about going in front of the judge.
Okay. So let's say if I am as a landlord filed for eviction myself, I went through this whole process and now I know that my court schedule is in 2 weeks. And now all of a sudden I receive this letter that the tenant has representation. Can I, as a landlord, go and get my eviction attorney at this point or not really?
Yeah, you absolutely can. Not a problem. The problem comes in where certain attorneys, I usually consider myself part of that. I won't take your case if you're that far in. I'd really have to review the case to make sure you did everything properly. Because if I take over your case and you did something that wasn't proper, theoretically, I could get sued for accepting the case and not realizing whether it was done or not. So I'd have to go through the whole case, make sure everything was correct, and make sure that I'm not going to get sued because you did something wrong. Because there's the Fair Debt Collection Practices Act. There's all sorts of things that, we as attorneys know not to do, but landlords who are going in there aren't 100% sure about.
So let's talk about that a little bit. So what would you say common errors or issues that you see on the landlord's part if they do it themselves? Like what kind of problems can they have when they file for eviction?
So the biggest problem that I see is they don't have their correct paperwork. They don't have their licenses lined up, their certificates, their lead safe certificates, and they sue for all the rent that they're owed. They think they're owed, but if you don't have the proper licensing, you can't ask for it. But they're asking for it anyway. If I do that, I can get sued under the Fair Debt Collection Practices Act for filing for monies that I know are not due. That's the biggest problem.
Can the landlord get sued for that as well?
So that's a good question. I'd have to look that one up. I believe, and you can't take this for, if you're an individual, it's your property. No. But if you're a property manager who's going in and representing them, or someone who's not named, so if it's an LLC and you're an individual going into authorized rep, I believe you can, yes.
So you see property managers representing landlords as well in court?
Not too much anymore.
Yeah.
They used to, but not too much anymore.
I would think so. I would not do that.
You're opening yourself up to a lot of liability and headache that you just don't need.
Correct. So let's say we are in court now, and again, it's a second mediation at this point. So we reached an agreement. Let's say it's a payment plan, or tenant needs to vacate at a certain point. What happens after?
So we would write it up in court. There's computer systems in there. We'd type up the judgment by agreement. The tenant would sign it. It would get entered on the docket. And if they keep to the payment agreement, great. They get to stay. You get your money. Everyone's happy. If they don't, then we would file a breach of the agreement. So the tenant would get notice that they didn't keep to the agreement, and we'd start our writs, and then the lockout procedure begins.
And what happens if during this mediation on the court date, we cannot come to an agreement? What happens then?
So theoretically, and doesn't always happen that day, as I said, a lot of times it'll get continued for an actual trial date, because either we're not ready, the tenant's not ready, the tenant's attorneys aren't ready. But if we can't come to an agreement, then the case goes in front of the judge, and both sides put their case up, and then the judge will make a ruling on the facts that they hear.
And how often, through the cases that you have, how often that happens? How often do you actually go in front of the judge versus signing an agreement?
You don't go in front of the judge very often. What I always tell my clients is, if you go in front of the judge, you are putting your case in the judge's hands. You have no idea how the judge is going to rule. They could rule for the defendant, in which case you're out of luck. They could rule 100% for you, in which case, great. But, and we'll get to this in a second, there's what's called a de novo appeal if you go in front of the judge. In my opinion, if you can make an agreement that both parties can agree to, both parties can agree to, it's better for both sides, because that way you know where you stand at that point. You didn't give your case up to a third party to decide what's going to happen. Sometimes you just can't come to an agreement. But if you can, to me, it's always a benefit, because that way there's no appeal. The problem, if you go in front of a judge, there's what's called a de novo appeal, which means they can go to common pleas court regardless of win, loss, doesn't matter. And it's a brand new case over there, and it's a lot more expensive because it's a full-blown case, and it takes a lot longer over there. If it gets appealed, it's not fun.
Yeah. Well, that's the part where a lot of landlords hang up or cannot get their head around, is why would I sign some agreement? If I'm at this stage, I'm at eviction, I'm at the court, I want you out. I don't want to be talking to you, and I have all of this case that you're destroying my property, or you're not paying my rent, or whatever else is happening. Landlord is not happy at that point with this tenant. And I was there as well 10 years ago when I had my first eviction happening. I could not wrap my head around, why would I agree to something if this tenant has not been paying for the last few months? I want this to go in front of the judge. And it is hard to understand, especially if you go in it.
Especially for new landlords.
Yeah.
The advantage to doing the agreement is certainty on your behalf. You know, if it goes bad, you have an idea of how long it's going to take you to get them out. You have an idea of how much it's going to cost you to get them out. You have a time schedule, and you're theoretically done with court. If it goes in front of the judge, now you're in this is assuming they appeal it. If it goes in front of the judge and they appeal it, now you're in a totally different court on a totally different schedule. You're paying additional attorney fees, which are way more expensive than going to municipal court attorney fees. And your timeline is different. You have no idea how long it's going to take you to get them out over there. So it's more about the certainty that you have as a landlord by doing the judgment by agreement. If you go in front of the judge, not only do you have no idea what he's going to rule, but if either side doesn't like it and it gets appealed, now you're in a whole nother case in a whole nother area, costing you a whole bunch more money, and you don't have the certainty, and you got a bunch of more hearings to go attend. So it's time, it's money. A lot of times, that's a consideration you got to take in when you decide whether or not to go in front of the judge. Sometimes you don't have a choice. Sometimes there just is not an agreement to be had, and you have no choice but to go to that path. But if there is a choice, a lot of times it's a better choice to agree just for certainty.
Yeah, that makes sense. And if or when you go in front of the judge, do you see that our judges in the city, they more tenant friendly or landlord friendly, or it's all over the place?
I would say most of the judges are very fair. I don't want to get into who's landlord friendly and who's tenant friendly, but I would say most of the judges do their best to be fair and honest. And if you have your paperwork and you as a landlord have done the right things, you'll have a very good shot of winning. If you're a landlord who, just got your certificates and just did this and you haven't done your repairs, and the tenant can come in and show the place is disgusting and you're not doing your repairs, it's not going to go well for you.
That's a separate topic about the repairs during eviction, and I think we need to talk about that as well. But before we get into that, right now we are at the timeline, at least 3 months once we get this agreement signed at court hearing, because we have filed for mediation or for eviction diversion program. Then we waited for 30 days. Then we filed for eviction. We waited another 30 days to get the hearing date. So it's been 2 months now, right? And now we sign in this mediation agreement, which usually something should happen within 30 days. It's either a payment or...
So the rule is you can't file after judgment, you can't file your writ for 11 days after the judgment. I believe it's 11. Pretty sure it's 11. It's 10 or 11. Nothing's going to happen for that next 10 or 11 days. If they don't make their payment, or you just want to start the eviction process after that 10 or 11 days, you file your writ, then the writ gets served, and then 10 days after that, you can file your alias writ, which is what schedules the lockout. So realistically, with getting it filed and having the court approve it and getting it down to the sheriff to get it served, I mean, you're looking at another 30 days. The quickest as of right now, if you could get a 90-day lockout, you should be loving life. The problem we're running into right now is the sheriff's taking a considerable amount of time to actually schedule the lockouts. And that's where the big delay is, right?
Is that 90 days from the time when you got the judgment, or from the time when you filed your writs?
So 90 days from the start of the case. Okay. That would be, great. Not going to happen. Right now, 60 to 90 days from when the alias is filed is when the sheriff's scheduling lockouts. So you're really realistically looking at, I say 6 months from the time you start, give or take. It could be a little longer, it could be a little shorter. There's continuances, there's answers to breaches, there's petitions. But, I would say 6 months is a roundabout good area.
And it all depends on how the case goes, and if you accept TFA, you don't accept TFA, how mediation goes.
Right. Every case is individual. You can say that, they're all similar, but every case based on its own fact has its own path. And some tenants who know what they're doing can delay stuff a long time.
Yeah. And unfortunately, we see that happen pretty often. So you touched a little bit on that, the repairs. So let's say we are in the court, and by the time we get to the court, again, it's been at least 3 months since we started this process. That means that tenant was behind at least 1 month before that. So that means that we already have some kind of bad relationship with the tenant for at least 4 months up to this point. And usually when that happens, tenants stop paying. They're not very responsive or not cooperating. They will not let you into the property. And I don't know, let's say during the process, tenants send you a maintenance request that, I don't know, there's a hole in the wall or whatever else they can send,
Right.
some kind of maintenance problem. And some of them that we've dealt with before, they would call L&I to have L&I out, do the inspection of the unit, and then they will submit that to you. So you receive the fine from, or not the fine, you receive the letter from L&I saying that you have certain amount of time to do the repairs, and you want to do the repairs, but the tenants won't let you in,
Right.
and then they won't let the L&I inspector in again. So how does that work? How do we do that in court? Quick update, our Jumpstart Northeast Philly program is live and we're accepting applications now. If you are in Northeast Philly and you're looking to learn how to find, buy, finance, fix, rehab, sell, or rent a property in Philadelphia, this program is built for you. It is based on proven success of Jumpstart Germantown program and focused on building local wealth while improving our own neighborhoods. You also will hear from multiple industry experts such as lenders, contractors, zoning experts, and more, sharing real practical knowledge to help you succeed. Don't wait, space is limited. The first program is running in September. The application process is open. To apply, click the link in the show notes or go to TrustArtRealty.com, select resources, Jumpstart Northeast Philly.
Well, yeah, it's a problem, but the best thing you can do is document everything that you do. So show when the inspection was done. If this gets into court for the landlord-tenant case, show when the inspection was done, show every attempt you made to contact the tenant to schedule it, to send people over to do the repairs. The judges will look at it. I mean, it's a good reason. If you tried to do what's right and the tenant won't permit you, most judges will see you did what you were supposed to do. But if it's just they did it and you totally ignored it, the judges will also take that into account. And you're probably going to get reduced rent, if not a judgment for the defendant, because you just let them stay in there. And, if especially the big things are heat in the winter, that's a no-no. If you have a heat problem, in the winter, you need to get over there as soon as possible and remedy it. That's a big no-no. The other big no-no is bugs, roaches, any kind of infestation. That's also a big no-no.
That is interesting about the bugs and whatever infestation it can be. Is that only for multifamily units or single family as well? Because from my understanding, a single family, it's the tenant's responsibility to treat the place.
So first you have to look to the lease and see what the lease says, because a lot of the leases will have in there who's responsible for it. But yes, in single family homes, the rule is if it's a single family home, you have to provide them with a rodent, an infestation free property when they move in. But once they're in there, they're responsible for it themselves. And like I said, unless the lease says different. For multifamily units, the owner's responsible.
Doesn't matter what the lease says.
Not really, because it's not really fair. I mean, if you think about it, it's not really fair to the tenant if there's one tenant who's really good and the other tenant or other tenants in the property are bad as far as, infestations are concerned. How does the good tenant keep their place clear if the bad tenant isn't, and they can't get into the other unit to spray the other unit? So that they really put the onus on the landlords on that.
What happens if your rental license lapses during the lease term and you need to file for eviction? So let's say we're filing for eviction today, which is May 6th. We're recording it on May 6th. And my rental license was active or is active, but it's going to expire in June.
So you can file today. You can ask for rent up to the time of expiration, but you better get your new license before you get to court. They will not give you a judgment in court unless you have an active rental license. And you cannot ask for any rent during the period of the lapse. So it makes a lot, it's really important to keep your rental license active.
And if we change the example a little bit. So we're filing in May again. We had rental license, but rental license ended December and was not renewed until January. Would we be able to claim rent for December?
No, plain and simple, no. If you go to court, you can only ask for rent for the time that you had active rental licenses, your certificate of rental suitability was good, and your lead safe certificate was good.
Now, if we had rental license at all of this time, but we go to file and we find out that there is this rental suitability certificate that we need to have, and we did not have that, can we claim?
No, you have to have all of them.
So what do we do at that point if we have unpaying tenant, we have rental
Well,
license?
it is a correctable problem. So you can go print out your certificate of rental suitability and the Partners in Good Housing Handbook, serve it on the tenant, and then you can ask for rent from that point going forward. But you lose all your old rent, can't ask for it.
That's a hard hit to find out that way.
Well, and I believe my recommendation for all landlords, property managers, when you have the tenant come in to sign all the lease documents, you should have your rental license, your certificate of rental suitability, your Partners in Good Housing Handbook, and your lead safe certificate there, and have the tenant sign and date each one and keep a copy in your file. That'll save you a lot of headaches going forward. If you just let them in without those documents, it's a crapshoot.
What happens if, take our last example, that we're filing now in May, and we find out that we didn't have rental suitability certificate. Now we print it out, we send it to the tenant, and we go to court, and we'll go in front of the judge, or maybe the tenant has a representation.
Mm-hmm.
Can they make the landlord pay back the rent that tenant paid during the time when the landlord didn't have active rental license or rental suitability certificate?
No. The case law as it stands right now is once the tenant pays that rent, they cannot claw it back. But that's only for the rental license and the certificate of rental suitability. If you were required to have a lead safe certificate, and in order to get your license, you're required to get that. But let's just say, for the sake of an example, you didn't get your lead safe certificate until 6 months after the lease started. Theoretically, the tenant could come in and sue you for those 6 months to get their rent back.
Have you seen that happen before?
Yep.
And
not uncommon.
Really?
Really.
So how does it start? Is it the tenant that sues the landlord, or the other way around? How?
So normally the way it starts is the landlord goes in and sues for eviction, and they either get a tenant's attorney or they do enough research on their own and they realize it's like, oh, they didn't have their lead safe certificate because we have to provide it in the filing until a certain date. We can sue you for that. And sometimes they just use it as a negotiating ploy too. That, okay, you owe us 6 months, we owe you 8, we only owe you 2 now. Are you okay with that? But yes, the law is what the law is. And if they know it and proceed on it, you're opening yourself up to a lawsuit. That's one of the things why when you give me all your paperwork, I got to look at everything and make sure, because you need to know that before you go into court. It doesn't happen on every case, but it's not uncommon either.
Definitely not an easy city to navigate all of that. What do you actually do if, let's say, another hypothetical situation that we're in? We have rental license, we had rental suitability certificate, and we had our lead inspection done with the certificate, but it's valid for 4 years.
Right.
So it's been 4 years, now it's expired, and we cannot renew rental license until we have new certificate or until we have new test done. And of course, it happens right at the time when tenant stops paying, and they will not let us into the apartment or into the property to do the test. Is there any remedy for that, or how are we able to still do something?
Yes. Theoretically, sometimes if you can prove all that to the city, they'll give you a waiver, and they will give you a new license because you had the old certificate. The city will give you a waiver. I believe it's a 1-year waiver to get your new lead certificate based on this. But you need to prove to them that you've been trying to get in there. So you need to show attempts to get in. You need something from your lead inspector showing that. And then once you get to court, then we need to show the judge all that, hey, we've been trying, they won't let us in, can we proceed? And depending on, sometimes the judge will order them to let you in to do the lead safe certificate, then they'll let you proceed. Sometimes they'll just let you proceed at that point because it's not fair to the landlord that the tenant is restricting you from doing what you're supposed to do.
Where do you go to do that? Do you go to LNI first, or do you?
If it's the violations, you would need to go to the inspector and talk to them. If it's for the lead safe certificate, you'd need to go to where you renew your license and show them and see if they'll give you a waiver.
Okay, makes sense. Let's switch the gears a little bit and let's talk about utility bills and specifically water bills. So what we often see is that landlords, especially for multifamily buildings, would split the bill between the tenants. So let's say we have a 3-unit building, and in city of Philadelphia, we always have 1 meter water meter per building. So we have 3 units, and the landlord splits the bill between the tenants for whichever amount.
Right.
It's either 30, or whatever they split it. So if they do that, first, can they legally do that? And second, if they do that, can they claim that in court?
Theoretically, so there's some of this depends on the judge. Legally, no. In order to charge water, you need separately metered units for each unit. But the lease is a contract. And some judges will find if they agreed to it, then yeah, you can do it. It's not a huge headache. I generally say if it was me watching everything, if you have 3 units, rather than charge them each individually water, why not just raise the rent for the water and just charge it as rent? Some months you win, some months you lose, but if the unit eats up, $150 worth of water every month, just raise everyone's rent $50 and don't even bother with the water.
Yeah.
That's the safer way to do it. Or have them individually metered but I believe that's pretty expensive.
That is very expensive, and you will have to have some company that will be doing sub-billing besides the sub-metering. That is expensive. It doesn't make sense to do on a small scale unless if you have some kind of big apartment complex, maybe at that time.
The other problem with it is, regardless of whether they pay or not, water bills are liens against the property. So even if the tenant doesn't pay it, theoretically, the owner's still responsible for it.
Yeah, which is a great segue to my next question. So that was multifamily buildings, but now we have single family, and in single family, there is no problem. We can bill it back to the tenants, which we usually do. And what we usually recommend people, never put water bill onto the tenants or in the tenant's name. It always has to stay with the landlord, but you can just bill back the tenant for the actual water usage. So let's say the landlord rented the property. They told the tenants that they will have to pay water bills. And the tenants never did. They just didn't pay water bills. And now the time comes when tenants move out and landlord finds out that there is, $1,500 water bill that was unpaid with late charges and all of that. Can the landlord deduct that from tenant security deposit?
100%. As long as the tenant was responsible under the lease, yes, you can take it out of the security deposit.
Does the lease have specifically say that it's tenant's responsibility to pay for water?
Well, it has to say, yeah, they're responsible for water. Normally on the standard leases, there's a little checkbox.
Well, that makes it a little bit easier for some people. But hopefully the way to do it, it's actually for the landlord to pay the bill themselves. And
I agree with that, because that way you can monitor it and if they're not paying you.
Yeah.
At least you can keep the water, because at least you can keep the water on, and if it's getting too big, and then you can put them into court to get them to pay the water bill.
Oh, that's another interesting topic that you just touched. Keep the water on. So I've heard that many times, speaking to landlords who's having issues with tenants, that they would say things like, oh, they stopped paying, so I will just go and shut off gas or water to the building, so they will move out, or I don't know, take the front door of the building off for the repair. Can they do that?
Totally illegal. They can get sued for self-help eviction. They can get sued for lots of things. I would not recommend doing that. If the tenant takes you to court under that scenario, there isn't a judge around who isn't going to hit you with a fine if they sue you properly, and let them right back in and order you to turn the water on, turn the heat on. Yeah, you don't want to do that. they call it a constructive, I was looking for the term, it's constructive eviction. You're trying to kick them out by turning off their utilities, and you're just not allowed to do that.
Yeah. If we were, everybody would go and do it.
Right.
There is, we were talking about eviction all of this time, but there are two different things that we need to know: eviction and ejection, right? And
Exactly.
can you tell us what is the difference between eviction and ejection, and when we should use one or the other?
If you have a landlord-tenant relationship and you have all your documents, you should always go to municipal court. It's cheaper, it's quicker. Ejectment actions are for squatters, basically. So that's for when you have a vacant property, you go over there and there's someone in the property and you need to get them out. Ejectment is how you get a person out when you don't have a landlord-tenant relationship with them. You didn't let them in, they just moved in on you, or someone else moved them in under, a false lease or whatever. That's the big difference. But if you can go to landlord-tenant court, 99.9% of the time is the way to go. It's, like I said, it's cheaper and it's quicker.
Okay, so when we actually go to the court, what should landlords bring with them to eviction court? Like any documents, any proof of things?
As all the judges say, today's your day in court, bring everything. Oh, I didn't bring this with me. And the judges look at you and go, well, today was your day in court. Why didn't you bring it? You should bring your complete file, regardless of whether you think you need it or not. You get in front of a judge, cases sometimes take weird turns, and you need to have proof that you repaired, I don't know, a window a year ago because they're complaining about it. And we didn't even think it mattered because it was done a year ago. But the tenant's like, well, I had a window, and they didn't repair it for 6 months a year ago. And you can, so you bring your whole file. That way you have no problems, regardless of which way the case goes. Who knows if someone wants to see a rental license from 2 years ago, or will start coming up a lot more with the 4 years of the lead certificates. I only need the current lead certificate to file right now. But what if they want to sue you or try and, they want to see an old lead certificate? Well, if I don't have it in the file and you don't have it, we either need to continue it or it's going to be a problem. So you bring your whole file. That's best practice.
Yeah. So you have to have records. You have to keep good records of
everything.
Yeah. And have that. What are some of the most common mistakes that you see landlords make that hurt their case in court?
Obviously not having their proper documentation. Trying to rent a property without your rental license, without your certificates, without everything, that always comes back to burn you in the long run. The other big one is not doing repairs timely. If the tenant, requests that your heat, it's the middle of the winter and they don't have heat, A, it's not good for your property. But B, you're not going to get rent if they don't pay you and they come to court and say, Your Honor, they didn't fix my heat for 3 months. That's not going to look good for you. And then the other thing is leaking roofs. All the basic maintenance stuff is where the judges don't want to see that.
What do they consider timely? We don't have any specific.
So it depends on the repair. A heater being bad, well, you don't even need to give them heat in the summer. So if the heater went bad in the summer, timely would be before the winter. But if the heat went bad and it's 20 degrees out, timely will be as Your Honor, I called my guy. They called me at 9:00 at night. I called my guy first thing in the morning, and he was booked up. He got over there in 2 days. That's considered timely. But if you go, yeah, I called my guy and he can't get out there for a month, that isn't going to fly. Call someone else. You got to get someone over there, even if it's just a temporary repair, to get the heat back on.
Okay, as long as you show your best effort that you actually try to do that.
Correct. Now, cosmetic things, if it's not affecting the livability or the habitability of the property and it's just cosmetic, timely could be 30 days, 60. A lot of it depends on what the repair is. A leaking roof, A, you want to get that done because it's damaging your property. But B, 2 months isn't going to cut it on a roof repair, under 30 days. Normally 30 days is a good cutoff for most things. Over 30, they're not going to be happy. Under 30, as long as you can see that you've been on top of it and scheduling everything to get people over there. Anything other than heat, I think or, something that would get them out of the house. Like if there was a window that was broken out on the first floor that wasn't the tenant's fault and you were responsible, you got to get someone over there, at least at a minimum, to board it up as quick as possible so you can get the window, fixed. If the stairs, they can't use the upstairs because the stairs are bad. Plumbing, a plumbing leak in the basement where it's flooding, or, a toilet that's not working. Now you're down into the under a week type of thing as opposed to, 30 days. So each one is individual, but let's put it this way. If you were living in the house, how quick would you want it done? In your own house. If it's the only bathroom in the house, I need that fixed ASAP. I need my heat fixed. If you have 2 or 3 bathrooms in the house and one of them's bad, okay, 30 days is probably reasonable.
You try to fix it for the tenants much quicker than what you do for yourself. So, Len, when does it make sense for a landlord to bring in an attorney instead of trying to handle things on their own?
10 years ago, when we first met, you could probably do it very easily as a landlord. Nowadays, I'm not sure I would recommend any landlord going there without representation. You can do it, but let's say you go in as a landlord and you did your own diversion, and you didn't do it properly. If they find, if the other attorney finds you didn't do it properly, or the judge finds you didn't do it properly, they're going to either dismiss your case or rule for the defendant. Now you've just wasted 60 days. Those 2 months rent that you didn't get, you could have easily paid an attorney, and you'd be, hopefully if they did it, the attorney does what they're supposed to do, you're not another 60 days out. So unless you know what you're doing, I recommend getting an attorney.
And what would be your top piece of advice for new or smaller landlords who may not be familiar with the legal process? What would that be?
First of all, you may want to get yourself a property manager if you don't want the headache, because it's a job. You can't just buy a house, rent it out, and think that, you're going to collect rent every month. As I had one client tell me one time, because I thought about buying and renting properties, he goes, if you're not going to do it as a business, don't even bother. He said, you can't own 1 or 2 houses and think you're just going to collect rent on them and everything's going to be happy. There's maintenance, there's requests, there's who knows what. In your own house, it's constant maintenance. Now you got 2 or 3 houses, you have a regular job and you're trying to do this. And property managers and bigger people, they have access to repair people like that. All they do is make a call. If you don't have access to that, all of a sudden you got to call, you got to go over there and get estimates. The property managers don't need to do that. The other big thing, do not rent to anyone without all your documents in line before you put them in. It always comes back to bite you in the end. And the best thing is, when they come to sign the lease, they're more than willing to sign everything because the parties are still on good terms. So you can get them to sign off on everything and you have it in the file and you're basically good to go. If you wait 6 months and all of a sudden they're not happy and hey, can you sign this certificate of rental suitability? Or can you sign this lead safe certificate? They may look at it and you may email it to them and they're just like, forget it. So get all your paperwork in order. You shouldn't be renting without it anyway. So have it at the lease signing, and it'll save you a lot of headaches in the long run.
Yeah, that's a great advice. And Len, thank you so much for joining us today. It's been a wealth of information. I'm sure, especially for newer landlords, it's a headache and your head may spin from learning all of this, but it's not that scary when you go through this multiple times. And Len's been doing it for 25 years and you have a lot of experience. So Len, remind me if you work with regular landlords. So if somebody is looking to start an eviction, can they reach out to you?
I do. Yeah, I work with individual landlords. I'd recommend you get a property manager, but yes, I do work for individual landlords. They can contact me at 610-247-1299 is my office number.
Okay, and we'll also add your contact information in the show notes. So if anybody is interested or want to get in touch with Len, call the number, and I guess he will take it from there. And Len, thank you for your time.
Thank you.
Yeah, we're good to go at this time. Okay, let's wrap up on today's show. So as Len mentioned, you have a lot of different requirements before you can go to court and before you can evict your tenant. Make sure that all of your documents are in place. Make sure to keep good records. Property managers are always a great help with that because most of them will have good records and will have system that can help them with that. But at least, for the very least, make sure that you have your rental license, rental suitability certificate, and the let certificate if the property was built before 1978, which most of the properties in our CA were. Before you can file for eviction, you will need to have eviction diversion program. And only after that is done, then you can file for eviction. Let's wrap up on today's episode. Big thanks to Len for sharing this time and his legal insight. So if you would like to get in touch with Len, his information is in show notes. And again, thank you for joining in. See you next time. Bye.